Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty here at iExamB. How is your preparation going on for IBPS SO Law Officer examination? I hope it is going very well, and I have this video series I have started which you all must have seen, जो मैंने specifically IBPS examination से related law syllabus से related कुछ videos बनाए थे, most important question series. अगर आपने इन videos को miss कर दिया है, then I would suggest all of you to subscribe to Legal Bee as soon as possible. Check out all the videos of this series. ये सारे questions आपके लिए काफ़ी हेल्पफुल हो सकते हैं. इवन इफ इट इज़ योर लास्ट मिनट प्रेपरेशन, देन ऑल्सो डेफिनेटली इफ यू हैव अ ग्लांस इट कैन हेल्प यू इन रिवाइजिंग थिंग्स. क्या पता यहाँ से कोई क्वेश्चन आ जाए या कोई सिमिलर कंसेप्ट से क्वेश्चन आ जाए, सो इट विल डेफिनेटली हेल्प यू. आज के वीडियो में हम लोग डिस्कस करने वाले हैं 20 मोस्ट इम्पॉर्टेंट क्वेश्चंस फ्रॉम द टॉपिक भारतीय नागरिक सुरक्षा संहिता. आई वुड से भारतीय नागरिक सुरक्षा संहिता बिकॉज आई हैव अपडेटेड and I have made the questions according to the new law. यानी कि BNSS CRPC के बेसिक सब्सटैंशियल कंसेप्ट तो सब सेम ही हैं, बट जो चेंजेस इनकॉर्पोरेट किए गए हैं उसको ध्यान में रख के भी मैंने कुछ क्वेश्चंस यहाँ पे कवर किए हैं. सो डेफिनेटली इट विल बी वेरी हेल्पफुल फॉर यू. Do watch the video. कोई भी queries हो, reach out to us directly in the comment section of the video. You can also write to us on hello@iexamby.com. Call us on the number 920552408 or visit our website www.iexamby.com. So IBPS examination, that is for law officer, means examination आपका आ चुका है. So the most important questions we'll directly start discussing. The first question from the series: all proceedings for investigation under Bharatiya Nagrik Suraksha Sanhita are conducted by police officer, any person authorized by magistrate himself, both A and B, both A and C. So the question is very simple. Investigation के बारे में पूछा गया है. There is a direct definition for investigation that has been providing which covers this. So the answer is D. Police officer and any person authorized by magistrate. Section 2J of BNSS talks about this. Investigation, which includes all the proceedings under the Sanhita for the collection of evidence conducted by a police officer or by any person other than the magistrate who is authorized by a magistrate in this behalf. What is the definition of a police report? Police report, which is also known as charge sheet, you all are correct. इससे रिलेटेड क्या अभी प्रोविजन है, इवन सेक्शन नंबर अगर आप देख लें एक बार सीआरपीसी का तो आपको पता ही होगा. बीएनएसएस का भी सेक्शन नंबर देख लीजिए एटलीस्ट. ये सारे लैंडमार्क सेक्शंस अगर आप देखते हैं इट विल बी हेल्पफुल. So the definition of police report is report forwarded by a police officer to magistrate under section 173, report forwarded by police officer to magistrate under section 176, report of complainant recorded by police officer as per section 175, report of police officer forwarded to complainant after completing investigation as per section 176, report of police officer forwarded to the magistrate as per section 190. So the options make the question interesting, I would say this. इस तरीके के questions से आपको aware रहना है. कई बार कंसेप्ट बहुत ईजी होता है, हमें पता होता है, बट सिलिंग मिस्टेक्स ऐसे क्वेश्चंस में हो जाती हैं. So the correct answer is B. Report forwarded by police officer to the magistrate as per section 176. If a person fails to comply with the terms of notice, the police officer may arrest him immediately, may arrest him without warrant, may arrest him subject to order passed by the court, shall give another notice as a final reminder, shall give another notice as a final reminder, followed by arrest without warrant. So ये notice कौन सी है? This notice is when the police officer is going to start an investigation in a cognizable case, he is going to issue a notice to the accused. So अगर accused उस notice का जवाब नहीं देता है, fails to comply with that, then what will be the action the police officer can take over here? Correct answer is C. May arrest him subject to orders passed by the court. Section 35. Now 41A is not there. We have it incorporated under section 35. Clause 6 if you will see talks about notice and is further as well. So आप एक बार 35 ज़रूर पढ़ लीजिएगा BNSS में से. And अगर आप उसको compare कर लेंगे old CRPC में 41, 41A, these are the important areas. No arrest without warrant shall be made without the permission of dash in case of offence punishable with imprisonment less than 3 years. Deputy Superintendent of Police, Commissioner of Police, Deputy Commissioner of Police, District Superintendent of Police, Superintendent of Police. So arrest without warrant shall be made without the permission of dash. It cannot be made without whose permission? If the offence is punishable with imprisonment less than 3 years. So the correct answer over here is A, Deputy Superintendent of Police. Section 35 clause 7 talks about this. एटलीस्ट आपको डेप्यूटी सुपरिटेंडेंट ऑफ पुलिस से परमिशन लेना होगा अगर आपको विदाउट वारंट अरेस्ट करना भी है तो, अगर इम्प्रिजनमेंट 3 इयर्स से नीचे है. आइडेंटिफिकेशन ऑफ पर्सन अरेस्टेड इज कवर्ड अंडर विच सेक्शन ऑफ BNSS. यही आपको एविडेंस एक्ट में भी मिलेगा. आइडेंटिफिकेशन परेड, ये कंसेप्ट आपको पता होगा. सो दिस इज देयर इन द न्यू एविडेंस लॉ ऑल्सो, दैट इज भारतीय साक्ष्य अधिनियम, एंड इसमें को रिलेटेड प्रोविजन है. डू फाइंड दिस इम्पॉर्टेंट. यहाँ पे मैंने सेक्शन नंबर इसलिए लिया है कहीं कहीं ताकि आपके दिमाग में सेक्शंस भी रहे कहीं कहीं जो इम्पोर्टेंट एरियाज है. करेक्ट आंसर इज सी, सेक्शन 54, identification of the person who is arrested. So the procedure can be carried out by the magistrate. Executive magistrates can do identification parade. This concept is very important even in evidence act. Arrest can be made by police officer, magistrate, executive magistrate, private person, all of the above. So this is a very simple concept. Direct question is asked, who can make an arrest? ये सारे options में से आपको correct answer करना है. It can be made by all of the above. Private person, police officer, magistrate, even executive magistrate. All of them are having powers. As per 35, 40, 41 of BNSS, magistrates, even judicial as well as executive, private persons are also having powers. Police officers, obviously, they have power only. Service of summons to corporate bodies is made on director, manager, secretary, A and B, A, B and C. When you are serving a summons to a corporate body, it is made upon which authority? Correct answer is E, all of the above. Service of summons upon corporate bodies, firms and societies. Section 65 deals with this. Director, manager, secretary, all are covered in this. Attachment of property for person absconding is covered under 85, 86, 87, 89, 90. Correct answer is 85. Attachment of a person who is absconded. Absconded people, attachment of their properties. These are important sections, I feel, especially the ones who are applying for positions of law officer and all. They are in touch with these provisions practically. So this procedure, even who is an absconded person, all these things you should be aware of. So go through 85, 84. All this becomes important for you. Which of the following property can be attached after issue of proclamation? Movable, immovable, debt, both A and B, all of the above. So after a proclamation is issued against a person who is absconded, what kind of property can be attached? Whether it is movable, whether it is immovable, or whether it is a debt. Whether it is all of the above or only movable, immovable. Correct answer is all of the above. Section 85 covers this. After issue of proclamation, order of attachment of any property, movable, immovable or both belonging to the proclaimed person can be attached. Order for maintenance of wife, children and parents is now covered under which section of Bharatiya Nagarik Suraksha Samhita? 125, 124, 144, 145, 149. This section is also changed now. Landmark section hai. Do remember, this is important area. And remember the section number as well, the new one. I would suggest to be on a safer side. 144. At least the landmark ones, if you try to remember, it will be helpful for you. Order for maintenance of wife, children and parents. And then this provision is a lengthy one. I have not taken it completely now, but you have to go through it. Who all are in this category? Now next question is relating to it. Which of the following is, who amongst the following is not entitled to maintenance under the BNSS? Wife unable to maintain herself, illegitimate minor child, illegitimate child who has attained majority, illegitimate child who has attained majority and due to mental abnormality unable to maintain itself, illegitimate minor child who has mental abnormality. Who is not entitled, they have asked you over here. So that means only one is wrong and all of the others are entitled to maintenance. So यहाँ पे illegitimate child डाला है ना, तो थोड़ा सा confusion हो जाता है यहाँ पे. And wife also unable to maintain herself. So the correct answer over here is C, illegitimate child who has attained majority. That child has attained majority and he is illegitimate, then he is not entitled. Section 144 deals with this entirely in detail, as you can see over here. यहाँ पे मैरिड डॉटर भी दे सकते थे. So all this you have to be careful. यहाँ से क्वेश्चन में हम ट्रिक हो जाते हैं कई बार. FIR given by electronic communication. Now, so electronic communication related many changes have been incorporated now in the new Criminal Law Amendment Bills Act. So you can be updated with that. Positive changes are there. This is something which you can retain in mind, that electronic communication has been welcomed now. Even in evidence also, here also. FIR given by electronic communication cannot be taken on record, shall be taken on record within 3 days by person who is giving it, not be considered as a valid form of evidence, shall be a formal part of FIR. अब मैंने आपको ऑलरेडी हिंट दे दी है कि पॉजिटिव चेंजेस आए इलेक्ट्रॉनिक कम्युनिकेशन से रिलेटेड. यू कैन इजीली गेस द आंसर ओवर हियर नाउ. पॉजिटिव आंसर होगा, बट देयर इज अ कंडीशन दैट it shall be taken on record within 3 days by the person giving it. This is something which is the correct option. It shall be taken on record within 3 days by the person who is giving it. यानी कि 3 days का time period यहाँ पे दिया हुआ है. Section 173 is now dealing with FIR. You can see here electronic communication has been added. New provision of dash has been added to 173 for information received in cognizable cases for 3 years or more, but less than 7 years. What has been added over here? A new thing has been added for which kind of offences? For cognizable offences for 3 years or more, but less than 7 years. So the correct option over here is B, preliminary inquiry. Information in cognizable cases 173 clause 3 talks about this. Non-cognizable case cannot be investigated by police officer, can be investigated by magistrate only, cannot be investigated by police officer without order of magistrate, cannot be investigated by police officer without order of superintendent of police. So a non-cognizable case, answer is D, cannot be investigated by police officer without the order of the magistrate. So this is only the speciality about the NC. It is registered, but it is not investigated without order of magistrate specifically. This is the basic difference between cognizable and non-cognizable. Examination of witness can be made by the police, orally, writing, oral and writing in any form, oral or written, discretion of the police officer it is. This is also very simple question, but if you will see, when you look at the options for more than a minute, you feel that it is something which is confusing you. Such kind of questions you have to be careful. जो simple होते हैं, जो simple होते हैं but आपके लिए difficult लगने लग जाते हैं due to some reasons. So examination of witness can be made by the police. The correct answer over here is A, that is orally. Section 180 deals with it. Clearly दिया हुआ है that they will be orally, it will be done. Cognizance of offence by magistrate is covered under which section of BNSS? 200, 211, 210, 205, 208. ये भी section change हुआ है, important section है. Which section is dealing with it now? Correct answer is C, 210. Cognizance of offences by magistrates. And that is magistrate of the first class and also of the second class. No court shall take cognizance of offence of defamation for the first 6 months, first 1 year, after 6 months, after 1 year. Now this after and before is something which is starting from the date of offence, okay, or the date of knowledge of the offence. That is which is presumed from looking at the options. Except upon complaint made by the aggrieved person. So cognizance for offence of defamation will be made except upon complaint made by aggrieved person. It cannot be made by the court. So the correct answer is E. Prosecution for defamation, if you have to do, it will be only done when the person who is aggrieved comes with a complaint to you. Same applies for the matrimonial offences also. Court cannot by himself or suo motu take cognizance in those cases. This is also something which is logical, you can remember it. BNSS provides for supply of charge sheet copy free of cost to the accused, victim, both of them, accused and acid attack victims, or accused and victims of rape. This is also simple actually, we can guess it. Free of cost to the accused and victim both is the correct answer. 230 deals with that relevant provision. Supply to accused of copy of police report and other documents. When a charge can be altered, any time before judgment is pronounced, any time after trial is commenced, at any time before trial is commenced, at any time after judgment is pronounced also, but before execution of sentence of conviction, before execution of sentence of acquittal or conviction. So when can you alter a charge? This is an interesting question. Many students get confused. It can be done any time before the judgment is pronounced. Remember that. Section 239, कोर्ट में alter charge. Judgment pronounced होने के बाद तो it cannot be done. Which type of trial can be conducted by magistrate? Sessions trial, warrant trial, trial of summons case, summary trial, warrant trial, summons case trial, and summary trial. So which kind of trial can be conducted by a magistrate? This is something which we have to be very clear with. काफ़ी important and simple I would say question है. अगर आपका basic concept clear है तो magistrate can try summarily also, he can try a summons case and he can try a warrant case also. Sessions trial तो obvious है कि सिर्फ sessions judge ही try कर सकता है. So this was all that I had to deal. I had to come up with a short video relating to BNSS as well. I hope ये video आपके लिए helpful रहा हो. कोई भी queries हो, do reach out to us and prepare 50% faster with us at iExamB. Thank you everybody.